Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, and welcome everyone to the call of the Tennessee Court of Criminal Appeals February docket here in Nashville, Tennessee, February the 10th. This is the first case of the morning, and I want to thank the Supreme Court.
God save the United States of America, the state of Tennessee, and this honorable court.
I want to thank Supreme Court Clerk Jim Hibner for his introduction and for his staff's work in helping us keep these cases moving on a timely fashion, as well as the staff of the AOC. This is difficult times we're working through, but this is a wonderful alternative to in-person arguments at this time, and we thank the lawyers for participating as well. If you don't mind, Clerk Hibner, I'll let you call the case, and then I'll tell the lawyers how we will proceed.
State of Tennessee versus Javier Alexander Rivas and Hayden S. Fryer.
Thank you. I want to introduce the panel today from Columbia, Tennessee. On my right and your left, on my left and your right, Judge Bobby Holloway from Columbia, and on my right and your left, Judge Robert Wiedemeyer from Nashville. I'm John Everett Williams from Huntington, Tennessee. Each side is awarded 20 minutes. The appellant may ask for rebuttal time upon introducing himself to the court. With that, there are no preliminary matters that we know of. None of the judges wish to opine this morning. We'll wait their responses later on. To the appellant, it is your time, and it starts now. Thank you.
Thank you, Your Honor. Ben Russ of the Nashville Bar. I represent Mr. Javier Rivas. I would like to reserve 5 minutes of rebuttal time, please, Your Honor.
Yes, sir, and I'll try to keep up with that for you.
Thank you. Your Honors, I'm sure you're probably somewhat familiar with the case, but just briefly, as far as the facts go, this indictment involves two sets of offenses, and I'll go over the facts just briefly because one of my primary areas of focus is going to be on the severance issue and the denial of the severance of offenses. There were two separate locations in Davidson County. One was on Hopewood Court, where Miss Hobbs was killed in an attempt to burglarize her home, and then a street named Ludi Street, where Mr. Corbett was shot at while there was an attempt to burglarize his car. And basically, the same set of folks were involved in each, Mr. Rivas and Mr. Fryer, as well as two young ladies, both of which were cousins named Elliott, Miss Tanjanika Elliott, and the other Miss Elliott, who eventually were initially charged and later became cooperators with the state in this matter. So initially, it may appear that, this is a case where joinder makes sense of these two separate sets of offenses. And I believe it's counts 1 through 5 of the indictment are related to the situation with Miss Hobbs at Hopewood Court. Counts 6 through 9 of the indictment are related to Mr. Corbett and what took place on Ludi Street. You have the same set of actors. You have the same jurisdiction, of course. This took place in the same, day, night. It was approximately 2 to 3 hours in separation of time. It might have spilled over into the early morning hours of the next day, but essentially in the same 6-hour time frame. So again, initially, this may appear like a situation where severance is not warranted. Joinder is required. However, that would be erroneous. The trial court erred in several ways. First, in joining the offenses in the first place, because they were not properly joined either mandatorily or permissively. And then secondarily erred after the defense asked that these two sets of offenses be severed because they should have been upon request, even if this court finds that they were properly joined. The trial court put down an order in relation to Mr. Rivas's motion to sever offenses, which is included in the record, and I've cited it in my brief. Under Tennessee Rule of Criminal Procedure 8, dealing with joinder, the trial court found that these offenses were joined both as a mandatory issue and then secondarily permissively. I think the trial court is clearly in error that these are mandatorily joined. The plain language of the rule of 8A, which is mandatory joinder, discusses that if different charges arise from the same conduct or the same criminal episode, then they are joined mandatorily. Going through various case law that I've cited in my brief, the idea of what is a single criminal episode or the same conduct more or less boils down to, could a single act that results in multiple interrelated offenses, that is a single criminal episode. Episodes that take place in different time frames in different places, even if they have the same actors, are not the same criminal episode. And I think that's pretty clear under the case law. I think that the trial court is in an error in finding that these are mandatorily joined because they didn't clearly take place in the same criminal episode. As an example, you have counts 1 through 5 that all took place in a felony murder and then premeditated murder, as well as the burglary and weapons charges that are involved in what happened with Ms. Hobbs at Homewood Court. Those would be interrelated offenses. Those did transpire in the same criminal episode. And we would be disingenuous, I guess, if we were here asking that the court sever those offenses from each other, because that is the same conduct. However, these two separate incidents at different locations are not the same criminal episode. And I believe that the trial court clearly erred in finding they were mandatorily joined. I also think that the trial court erred in finding that they were permissively joined. The trial court specifically found under 8B1 that these two sets of incidents, or these two sets of charges, should be joined because they were part of a common plan or scheme. The definition of common plan or scheme is certainly one that's probably not new to the court. I know that this issue is argued somewhat frequently, and that the idea of a common plan and scheme is also discussed under the severance rule and Rule of Procedure 14, which I'll discuss here in a bit. But I think the case law that I've cited lays it out pretty clearly. A common plan or scheme can be one of three things under State v. Moore. It could either be something or a set of offenses that are so distinctive that they constitute a signature crime. One thinks of movies that has, a burglar that leaves a certain symbol every time he or she does something. I don't think that this could be considered any kind of a signature crime. Similarly, if they're part of the same criminal transaction, well, as I've just argued under the lack of merit in the mandatory joinder, this is not part of the same criminal transaction as it's interpreted in the case law. It's not the same criminal episode, same conduct, even if it took place in a somewhat close time frame. So that leaves the only basis by which they can then permissively join these sets of offenses if they are part of a continuing plan or conspiracy. And this kind of gets to the heart of what why I think the trial courts erred in both joining these and then failing to sever them once they've been requested, because the language of this section mirrors the language of permissive, or rather whether a permissively joined set of offenses should then later be severed upon request. The case law says that, a string of similar offenses is not the same thing. What this particular subsection of the procedural rules contemplate are crimes that are committed in furtherance of a plan that has a readily distinguishable goal, and that there's a working plan operating towards the future with such force as to make probable the crime for which the defendant is on trial. So one thinks about a set of crimes in preparation for a larger crime like a robbery that might take place, like stealing a car so that the license plate wouldn't be traceable or that wouldn't be distinguishable, so then you could later commit a bank robbery, or purchasing firearms illegally and that kind of thing. Something that then leads to a larger goal. The Neil Cohen in the Tennessee Law of Evidence stated that the unifying concept of crimes admitted under this theory, under the common plan or scheme, is not their high degree of similarity, but the common goal or purpose towards which each crime is directed. And I think this is where the trial court errs and where the state cannot effectively argue the opposite. These two sets of crimes were similar in motive, and they were similar in the people that committed them, but they were not towards a greater scheme, towards a greater plan. They have no connectivity towards each other than the similarity of motive. And I meant to, yes, Your Honor.
Let me just ask you that the way I understand it, four people got together, two girls and two guys, and they drive around looking for places to burglarize, or vehicles to burglarize.
Yes.
And if I understand it correctly, the two guys are in the back seat, the two girls are in the front seat there.
That's generally, yes, I think that's accurate.
And their plan is to steal stuff from people at their homes, primarily from their cars. And
generally, I think that's doing
that. And every time someone comes out and sort of catches them, the guys in the back seats start firing and ultimately kill one of the victims and shoots at the other group of victims. That seems pretty much the same plan to me.
Well, first of all, I don't know that it's entirely accurate. The second incident, they actually approached the door of Miss Hobbs' home and then either knocked or rang the bell. When she came and opened the door, it's disputed about who did what, but essentially she saw that they had weapons and tried to close the door, and then either Mr. Fryer or Mr. Rivas, I think they debate about which one fired on her and ultimately killed her. So I think that factually is a little bit different, but generally, yes, the idea was to find either cars or property to take and firing on them. I mean, again, this kind of makes my point for me in some ways. The idea behind each crime was similar. That's true. I mean, obviously, burglary of a car versus burglary or attempted burglary of a home is not that different. Taking property that doesn't belong to you for either use for drugs or other things is not that dissimilar. And obviously, you have the same actors. But again, the similarity between the offenses is not the point. The point is, are these two offenses going towards a greater plan or goal? And simply trying to get money, I don't think is sufficient to meet the standard that the case law and the code talks about. Obviously, the main reason for most crime is to get money for some reason or the other. So in that circumstance, I guess it's as similar on motivation as selling drugs is to robbing people. They're both trying to get money. So again, I would respectfully disagree with the ultimate conclusion. The facts are somewhat similar. That's true. And obviously the actors are similar. The jurisdiction is similar. The date is similar. But again, that kind of gravitates back to my point that, again, the theory is not that the high degree of similarity, but the common goal or purpose towards each crime is directed. And so I don't think that contemplates a similar, an identical motive, because I think, again, the motive for most crime could be considered to be very similar, regardless of the type of crime: burglary, robbery, drug sales, and that type of thing. So again, I would argue that the trial court erred first in joining these cases under either 8A or 8B in the first place. But even if this court doesn't find any merit in that, I think the trial court then erred in refusing to grant the defense's request to sever the offenses. And again, this kind of gravitates back to the same idea. In order, under 14B, it states, the rule states that severance is mandated, that a defendant has the right to a severance if these have been permissively joined, unless these are part of a common plan or scheme, and one set of offenses would be admissible in a trial on the others. I don't think, and I've argued this in my brief, but I don't think that on either score that the proof offered, that either prong of that is met, and the trial court is erred by denying the severance. I mean, again, as far as a common plan and scheme, I don't feel that this is a common plan and scheme simply because there's a similar motivation. I will point out too, and 2 points that I meant to argue briefly before. One, I don't think that prejudice here is an issue. I think it would be hard to say that any advantage inures to the benefit of the defendant to have more crimes to defend and have more violent crimes to defend in the same indictment. So I think that the joinder of these offenses certainly prejudiced Mr. Rivas. Secondarily, the court may note that under 8B2, which is not the section of the rule of procedure that the trial court used in order to join these offenses, but if they are similar in nature, then they could perhaps be joined. I would maintain that the trial court still erred because it is basing its ruling on something that I find to be erroneous. But even if the court feels that there was another manner in which the trial court could have joined these offenses permissively, it still doesn't defeat the fact that they have to be part of a common plan in order to survive a 14B challenge. And I don't think the court can do that under either theory under 8B1 or 8B2. Further, essentially what is set up in the second prong of Rule of Procedure 14B is a 404B analysis, whether the conduct in one set of offenses would be admissible in a trial of the other. And I would respectfully say that they're certainly not for several reasons. First, I would just remind the court that what sometimes gets lost in a 404B analysis by the trial court is that this, and this is in the advisory rules of Rule of Evidence 404B, is that 404B should be applied in the exceptional case. And that if there's an arguably relevant point, that's possible to admit other crimes, but that it shouldn't be common and that it shouldn't be frequent, and that there should be some relevance to the other crime being admitted. And of course, the court's familiar with motive, intent, identity, and things of that nature. I believe those are the three that the trial court cites as the reason it believed that the set of Hopewood court offenses would be admissible in a trial on the Ludi court offenses and vice versa. I would respectfully disagree with that. There was nothing in the defense proof that would have required rebuttal of identity, motive, or intent. Allowing the state in their case in chief to say, by the way, the defendant committed all these other really bad offenses, because he might argue down the line that it wasn't him, or he might argue down the line he didn't know what was going on, it was a mistake, he didn't have the intent to do those things, I think is really just trampling all over what the purpose of the rule is. That's not the exceptional case. And so I don't think that the admissibility under some some alternate reason other than propensity would satisfy here. I don't know how the motive, intent, or identity of Mr. Rivas in being present at Ludi would then permit the state to argue that he had the intent, motive, or identity to be at Hopewood Court. He made a statement in which he said that he was present at both. There was multiple state's witnesses that says he was made both people that were initially co-defendants with him as well as people that were not that said he was present. So the state doesn't need this evidence from one set of offenses to the other to rebut identity or to rebut motive. It's simply very nice for them to be able to say he did this thing, so he must have done the other without actually saying it out loud, which is exactly the reason that 404B exists. And what's more than that, of course, 404B has the other prong that the probative value can't be outweighed by the prejudice. I would again argue the prejudice here is enormous to have to defend yourself not simply on a murder, but an attempted murder that's unrelated at the same time. So how the probative value there is somehow outweighed by the prejudice to Mr. Rivas simply doesn't make any sense. I think that the trial court's abused its discretion all throughout the severance issue. And again, for the following reasons, I mean, I think, one, they should not have been joined. And I believe, Your Honor, I might have about 4 or 5 minutes left. Just to wrap up the issue of severance, and I'll leave my other arguments for the written pleadings, but I don't think that this is part of a common plan and scheme. And if it's not, then the trial court erred in having it joined, and then doubly erred in having it or failing to sever the offenses. And I'll just reserve the balance of my time unless there's other questions from the court.
General, let's hear from the state.
Good morning, Your Honors. May it please the court, David Finley on behalf of the state. Well, the trial court properly found that these should be mandatorily joined. They were part of the same criminal episode. The defendants set out to hit licks that night, and I submit to the court that that makes these part of the same criminal episode. We have cited to the court the case, the Cherry case, which is almost on point, except nobody got killed in that case, in which this case held that the state violated mandatory joinder by not joining a series of burglaries committed on the same day and in the same general area along I-65 in Williamson County. So these crimes were committed within 2 hours of each other, within about 4 miles of each other. I'm sorry, Your Honor. Was there a question? I'm sorry. So we would submit that these are properly joined under the mandatory joinder rule. As far as permissive joinder or permissive severance, are these part of part of a continuing plan? And again, we would submit they are. The defendants clearly set out that night, as Ms. Elliott said, to hit licks. They first went to Ms. Hobbs' home to check it, and there were too many people standing around. So they went to break into cars, and they ended up at Luty Street where they got caught and shot their way out of it, basically. And then went back to Mrs. Hobbs' home and kicked the door down, and she closed the door in her face, and they began firing through the door, killing her. So we would submit that certainly, was there a common goal with both of these crimes? It certainly was, to hit licks. That's undisputed, I think. Is evidence of one admissible in the other? Yes, it is. At the severance hearing, the defendant argued he would be unduly prejudiced by having both sets of crimes joined for trial. The trial court disagreed with that and also found that motive, intent, and identity were at issue. And as it turns out at trial, they turned out to be at issue. In his opening statement, the defendant, Mr. Rivas, said, well, I was with them, but yeah, I was just along for the ride. I was just trying to hang out with Miss Elliott. In his closing argument, well, let me back up. During his cross-examination of some of the Luty Street witnesses, and I think of maybe Detective Baltimore, he challenged the identifications that were made of the passengers, of the people that were shooting. And so he made identity an issue at that point as well as he did in closing. So we submit that motive, intent, and identity were all at issue here. So is the evidence of one admissible in the other? And yes, it is. Because the shell casings from both scenes were fired from the same weapon. The car used, it was identified at Luty Street as a kind of a gold-colored car. And it's undisputed that Miss Elliott drove a gold-colored car. Both defendants are seen leaving that night from Mr. Fryer's home, and both defendants are seen arriving back at Mr. Fryer's home about 4 a.m. with the weapons. So we can put them together. We can put them together with weapons. The shell casings from both scenes match, and their car is visible. Miss Elliott's car is visible on the video at Miss Thompson. So all this goes to prove the intent, identity, and motive. So we submit that evidence of one is admissible in the other. And finally, even assuming the court disagrees, this court has held that even when cases are impermissibly joined, the error is harmless where the defendant gives a statement, gives a confession. And in this case, we have one from Mr. Rivas. He admitted being there at both scenes. So we would submit any error was harmless beyond a reason.
Thank you, Mr. Russ. If you don't mind, the state has very well kept their comments to the argument that you made, and please keep your rebuttal to their argument. Thank you.
I will, Judge. I just have a few points about severance. One, what General Finley just discussed, because a defendant challenges some of the, challenges some of his culpability, which is what I believe Mr. Rivas was doing, does not necessarily mean that he is challenging motive, intent, or identity. Simply arguing that the state's proof may or may not establish who the identity of a shooter was does not mean he's denying that he was in the car or that there was somebody different than him there at either occasion. Also, because he may have thought that they were going there to burglarize a car doesn't necessarily mean he had the knowledge and intent that Mr. Fryer was going to start shooting at somebody who came outside, or if they were going into, excuse me, Miss Hobbs' home. So again, I don't think that that saves the state simply by what Mr. Rivas argued at trial. I don't think that that means that motive, intent, and identity are suddenly back at issue. I think he's arguing his culpability over the greater offenses that may or may not have been contemplated by hitting licks, as the Elliots described. And again, on that point, that's making my point exactly. Their motive was to get money. Their motive was to get money, who knows, from different people or burglarizing different cars. I think they talked about a car that they may have tried to burglarize that had an alarm they couldn't get into. So again, that does not, the same general motivation is not what's contemplated under the same common plan or scheme for the reasons that I've described. And one last point that I'll make regarding the potential prejudice and the admissibility of other crimes under 404B. In the McCrary case, which I've cited in my brief, it makes it clear that the similarity of offenses is an important factor for the trial court to consider when determining whether the admissibility of one set of offenses would cause undue prejudice. And I think that this, obviously, as the court has pointed out, the way that these two incidents unfolded was very similar. The charges were very similar. Obviously, the actors and even the weapons were very similar. So I think that case and that line of thinking was also ignored by the trial court. So unless there's any other questions, that's all I have to say.
Seeing no further questions, we thank you, gentlemen, for presenting the arguments this morning. The issues are certainly joined, and we'll ask the clerk to come in, and we will stand in recess to the call of the next case at 10 o'clock.
This honorable court is now in recess until 10 a.m.
Thank you.
All right, so we will put